have a script, have it displayed to the reps so they know exactly what to say to that customer and they're compliant, and then have certain practices in place where you are regularly auditing phone calls to ensure that they are properly disclosing that you are recording them.
And welcome everyone. This is one of the many content pieces that we are putting together in the weeks and months ahead as we help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules and updates to the TCPA, or Telephone Consumer Protection Act. We believe the content we're putting together will help you decode these changes with more confidence and a focus on compliance. Today's topic, Call If You Get Lost, a roadmap to interstate TCPA navigation, or coast-to-coast compliance. I'm Benjamin Farr. I'm the Director of Privacy, Security, Compliance at Active Prospect. The past 20 years, I've worked in companies in the performance marketing and market research space, including Dentsu and WPP Kantar, with much focus on privacy and data regulation compliance. I also worked at Ernst & Young in New York as an IT controls auditor in financial services and in the firm's internal privacy compliance program. Prior to that, I worked as an auditor at Ochsner Clinic Hospital in New Orleans, Louisiana, so covering healthcare and insurance. And in all my roles and functions, they're all in departments on legal, compliance, privacy, IT audit, and data security. And one development has continued through my career. In every one of these industries and jobs, a significant data regulation or law was passed, and I was on the team responsible for translating these new rules, seeking clarity, and establishing a compliance program. And now for a brief background and introduction, I'd like to pass the mic to my co-host today, Michael Paranto, Director of Professional Services at Active Prospect. Michael.
All right. Thanks, Ben. Really happy to be here today. So for everybody here in our audience, my name is Michael Paranto. I'm the Director of Professional Services here at Active Prospect. Just a little bit of background about myself. I've been in the CRM, contact center, and lead marketing space for over 13 years. I have worked for previous CRM organizations, including Velocify and Shape Software. I've done large implementations of contact center softwares, including Five9 and NICE and Contact, as well as been an administrator of those platforms with companies that I've worked for. So my previous work experience, I worked for a large organization called Cardinal Financial Company Limited Partnership. I was the director of lead marketing for that organization, where I oversaw a multi-million-dollar monthly lead buy. And the reason why I provided that context for you is because towards the middle of this webinar, we're going to be speaking about state-based TCPA regulations, and I'm going to talk about specifically some things to look in within your systems, your CRM and contact center softwares, to be compliant with those regulations. So that being said, I'm going to pass the baton over to Aaron. Aaron, go ahead.
Well, thank you, Ben and Michael. I'm Aaron Weiss. I'm a lawyer at the Carlton Fields firm in Miami, Florida. And like Ben and Michael, I've been in this space for a very long time, probably about 15 years of my 22 or so years of practicing law. So it's been a long time in this space. I think when I started in this space, I was doing mostly litigation, but in more recent years, I've been focusing very significantly on compliance in this space. And I know I speak a lot about these things. Ben and I had a chance to meet each other at a recent conference where I spoke about some of the state issues related to the compliance here. So I'm glad to have the opportunity to speak to the Active Prospect audience about state issues and related issues as will come up. And of course, my standard lawyer disclaimer that whenever, as Ben and Michael know, whenever you have a lawyer on the guest, my disclaimer that whatever I say is just my opinion, and people say I'm kind of opinionated, but it's not my client's or the firm's opinion or the like. But other than that, we'll have a great session today.
Excellent, Aaron. Yeah, really happy to have you with us today. And our previous sessions, we've been talking about FCC TCPA updates and FTC TSR updates. And for those out there responsible for operationalizing compliance, we thought it's a good time to have a discussion about U.S. state laws, right, and their requirements around calling and texting outreach and their communication allowances or restrictions. So, Aaron, can you provide a handful of examples of some of the state-specific communication requirements that could differ from the federal FCC and FTC requirements?
Absolutely, Ben. So I think whenever I talk about states, it's important to take a little bit of a step back and realize how we got to the TCPA and how that sort of was birthed out of states. So state regulation of outbound calling, that actually goes back to before the TCPA, which was enacted in 1991. In fact, the TCPA was supposed to be the supplement to state calling rules. To have, the idea was you would have your own private right of action in a small claims court because most of the states didn't have private right of action. That was like 30 years ago. What's happened more recently within the last few years is some of the states have now added on their own private right of action. So it's kind of become full circle. So with state regulation, we have to think about the regulation is both from the state regulators, which most of the states have some type of specific telemarketing rule, and then every state has some type of consumer protection rule, a lot of which cover telemarketing. But then a few states have their own private right of action. So, for instance, where I am in sunny and now very hot Florida, we've had for the last couple of years, when it first came into effect, what's called the Florida Telephone Solicitation Act. Now, it's been on the books for a very long time, but it was amended a couple of years ago to add a private right of action and also to change the definition of an auto dialer. So that's one example, Ben. Now, it has peeled back a little bit, and there's kind of a safe harbor provision. But Florida is a state that people still call out in particular, as you have to be very careful calling into. Another one, and that was not amended, is Oklahoma. What Florida and Oklahoma's laws were passed a couple of years ago. As I said, the Florida one was dialed back a bit, and there were, thousands of lawsuits in Florida until the amendment came on. But Oklahoma has its own law, also with the private cause of action, very similar to Florida, and that one hasn't been amended. Now, Oklahoma is not as big of a state, may have not as the same culture of plaintiffs, consumer protection lawyers, but that's certainly a state to watch out for. And then another one, just an example, and what I always say, you have to watch the space so closely because the laws, every legislative session, one state or another, and often it's more than one state are adding laws. So just recently, within the last few weeks, Maine doesn't have a private right of action, but what did Maine add? Maine added a requirement that you have to run numbers against the reassigned numbers database. That's the first state that I'm aware of that specifically has that very specific rule. So that, and under Maine law, it's now becomes a violation for not making running your numbers against the reassigned numbers database. But the theme is, look, we have 50 states. We all know about the TCPA, or at least I hope everybody on this call knows about the TCPA. But the real challenge is to be mindful that you have, 50 different states, all of whom have some type of law that is targeting outbound calling. And when I say outbound calling, most of them also include texting, but not all of them. So it's important to keep everyone, to have the mindfulness that there is a difference and different rules in different states, and you have to watch out for them as you're, considering your calling and marketing programs.
And so what's the best process for navigating all these sort of state-specific or mini TCPA law requirements? I know from a compliance mindset and the privacy space, we'll try to take the toughest standard and then apply that across the board. But is that a workable strategy for these mini TCPA requirements?
Right. So the challenge, Ben, is everybody can start with federal TCPA. And really, it used to be not incredibly difficult to say, all right, if you're complying with federal TCPA, you're probably complying with most states. I think the real big schism was after the Facebook decision in 2021, where Facebook, I don't want to get out ahead of my skis and suggest that Facebook, put open season on using auto dialers. I will at least say Facebook heralded a change in interpretations of auto dialers. And now all of a sudden, if the federal statute may not be perceived to be as restrictive, now people say, well, maybe I could use a certain technology, which I was on the fence about before Facebook. But now you have to peel back and say, well, hold on a second. Is that piece of regulated technology does that cause a problem in a state like Oklahoma, for instance, which has a more restrictive definition? The good news is there on a lot of things, there isn't too much that's too different. But the one thing that probably is important are the call time restrictions. Okay. And call time restrictions are, each different state, or not every state, but most states have restrictions on the time of day that calls could be made. Now, TCPA has its own restriction, but some of the rules in states are different. And there's probably roughly about half the states have their own rules for time of day and holidays. Here's what I would say for that. If you are making outbound calls, either debt collection type calls or marketing calls, you probably are using a CRM, a client relationship management system. You really should have the outbound calling time of day, on your CRM should be your solution to that. To try to manually figure out the time of day restrictions if you're calling into different states. Look, I could get it. Take the example of maybe you're, an individual car dealership. And this is, again, somebody's probably going to use this against me in some lawsuit for one of my auto dealership clients. But if you're only calling people, say, in your own state, let's say you're in Illinois that has its own time of day restrictions. All right, I get it. You're probably just making local calls. But if you're doing any type of marketing or debt collection calling that covers multiple states, you really should make sure that solution is on your time of day. I mean, after all, you have different states that have different holidays. I didn't know until I was preparing for this call that you can't call people in Louisiana on Acadian Day.
Right.
I didn't know that either. And, Aaron, I think you bring up a good point. When you talk about the permissible calling hours, a lot of the CRM systems and contact center softwares that are out there, but I see this a lot more with the CRM systems that have built in telephony. Often they have just a single setting for the allowed callable time. So they say okay, hey, only display leads or allow leads to be called between 8 a.m. and 9 p.m. based on that record's time zone where they reside. And some of them don't even offer the function to drill down to the state level. And you may not even know that you are out of compliance with it or have the capabilities to comply with the laws, depending on which CRM provider you use.
Right. And you have to be mindful, some of them are kind of weird. So for instance, in just as an example, just to illustrate how some of them are kind of unusual, in Pennsylvania, Monday through Friday, normal 8 a.m. to 9 p.m., very common. But on the weekend, Pennsylvania is 8 a.m. to noon on Saturday, and you can't call on Sunday. Can't call on Sunday is not uncommon, but that's kind of an unusual one, that noon.
Right.
Or Rhode Island, for instance, they're restricted on the weekend 10 a.m. to 5 p.m. So these kind of oddball ones that don't necessarily, look like other ones, if you're not programming for that, you're going to, potentially run into an issue. There is one more tip I like to always tell people when we're talking about time of day. And this is not just, of course, a state-by-state thing. I have seen a lot of clients of mine and others run into trouble on time of day with text messages. And what the red flag to look for is if you have, what I would call bulk text messages being sent towards the end of whatever the respective time of day restriction is, and you're not sort of paying for the high throughput. Meaning, so just as an example, if it's 8:50 p.m. in a state, for instance, like Minnesota, which has a 9 p.m. cutoff, and you're sending 200,000 text messages, all consented, all good leads. Let's assume everything is, 100% kosher about those, but you press send on the messages at 8:50. If you're not paying for sort of premium throughput, there's a very, very good chance that those text messages won't hit, at least, a good chunk of them.
That's right.
Until after the time of day restriction. So that is like the biggest red flag that I always tell people to watch out for on time of day.
You know, Aaron, I think you bring up a really, really good point with that too, because also some CRM providers and contact center providers on purpose will throttle the amount of text messages that they deliver to the carriers to then send it because they don't want you to be flagged as spam. And so with that type of a ruling or coding within their systems, they may inadvertently make you not compliant. So, you know, I think it's an excellent point because I've seen that happen in the past before as well.
Yeah, let's kick off a poll question because we can dig in a few more some of these specifics that are important. But let's kick this one off. So, and again, make sure you look at the poll section to provide responses for this. Have you recently reviewed your CRM or contact center platform for compliance with state-specific TCPA regulations? Options there, or yes, no, or not sure. This will help us give a better idea of the audience that we're speaking with. Also, state do not call lists, right, Aaron? That's something that not everyone is probably aware of, that there's a whole another avenue shelf there as well.
Absolutely. So there's 11 states that have their own do not call list. I'll run them off: Colorado, Florida, Indiana, Louisiana, Massachusetts, Missouri, Oklahoma, Pennsylvania, Texas, Tennessee, and Wyoming. So those states that I just read have their own version of the do not call list. And this is a real pain in the neck if you're not being careful. Because let's say that you're subscribing to the national do not call list, the federal do not call list. You're paying good money for that, and maybe even running your numbers against the federal reassigned numbers database. Well, the problem is the 11 states that I just read have their own do not call list that you separately register for. And you don't have to. You could be somebody who has not registered your phone number on the national do not call list, but have registered your phone number on the state do not call list. And now all of a sudden there's a claim that you could have. By the way, the federal do not call list, one of the hottest legal issues when I get federal do not call list class actions, has to do with whether the federal do not call list, some people call it the national do not call list, pertains to cell phones, because what the statute says is it pertains to residential lines. And the FCC has had a presumption. There's some court authority that says, well, it's a rebuttable presumption if you're using the phone primarily for residential purposes, but not necessarily for business purposes. Whereas if you're using it primarily for business purposes, you may not, even if you put the number on the federal do not call list. I say all that because that is not necessarily something that's in place in every state. So, you could get into, if you're wind up in one of these class actions with a state do not call list claim for one of those covered states, you may not have that same defense, which is, that's one of the bigger defenses that are available to defendants in these national do not call cases.
Very, very interesting. And also something to take note on with that, Aaron. I was going to actually cover that a little bit later, but a lot of your CRM and contact center softwares often will partner with third parties to help you comply with these state and federal do not call lists. Some of them that are out there, there's DNC.com, which is contact center compliance. You've got Possible Now and Griffin. You're going to want to actually approach whatever vendor it is that offers your telephony solutions and see which ones they partner with, and then sign up for that service if you want to stay compliant with those regulations. Because I could tell you it's very, very, very difficult to do that on a manual basis where you're like pulling lists and scrubbing it all the time. You want that to be automated because it's a disaster otherwise.
Right.
Yeah.
No, of course.
Yeah.
And what I always tell people, Michael, in this space, there are terrific vendors for everything possible in this space. And I know you guys have terrific products for documenting consent and picking up consent. And then there's others in the space who can assist with do not call lists. But the whole theme is don't do it yourself. There are people who have thought about these hard questions.
That's right. So Ben, does it look like we've got some results for the polls here?
Okay, let's see if we get the results of the poll. All right, we should be seeing that. And so we've got almost 40% that said yes, their CRM and contact center platform looks to see if it complies with state TCPA requirements. Another third says no, and then another third not sure. So evenly split throughout the group.
Yeah, and honestly, Ben, this doesn't necessarily surprise me. So my experience with, when I provided consultation work for clients that worked with CRMs or contact centers, is that a lot of them are compliant with the federal laws, but they may not even know that there are certain state-specific laws, or they know that there are state-specific laws, but there are certain requirements of that state-specific laws that they cannot comply with the softwares that they use. Now, my personal experience is like the large contact center softwares, especially the ones that have auto dialers, tend to have more features and functions available to help you stay compliant with these federal and state regulations. Those are the ones that are like, the 5.9s, the Genesis, the Nice and Contact. They've got large enterprise level clients that just require them to have these certain tools or integration partners available to them. Where you get into, or I've seen a lot of issues personally, is the CRM platforms that offer telephony solutions. Often they will have like a piecemeal approach where it complies with some of the laws, but not all the laws, or some of them it's only geared towards the telephony components of it and not so much the text messaging component of it. So you want to be careful and review both your CRM and your contact center software solutions to make sure that they are that they have the features and functions to help you stay compliant with these regulations. So if I was going through this myself, I've audited many, many softwares before. Here's a couple of things that I think that you should keep in mind if you were going to go down this route. So the first one is, you should obviously, we talked about this just a little moment ago, use an integration to comply with state and federal DNC lists. So again, don't do this as a manual process. Use the systems, use the providers that are available to you. Often both a contact center software or a CRM solution will have a partner that they use to help you comply with these regulations. Number two, you really need to think about with these systems, what fields you are using to calculate the time zone. So this is something that I'm going to spend a little bit of time on because it's a little complex in nature, but it's important to understand. So when you are ingesting records into your CRM system, these are often from lead forms. So the customer will go online, they click on an ad, they put in their name, their phone number, email address, property state, sometimes a zip code, sometimes an address, right? That information then goes into your systems. Once it enters into your system has to calculate what that time zone is if it doesn't have it, right? And so you have only a few fields to choose from to calculate that time zone so that you're calling them at the appropriate time. So one of the fields is the phone number. Now, if you're calculating off of the phone number, there's a couple things to really be aware of with this, is that number one, calculating off the phone number used to be more accurate, we'll say like 10, 15 years ago. Nowadays, not so much, right? We see situations like myself. I'm originally from California. I'm now in New York. My phone number's area code is still 714. So if your system calculates the time zone as Pacific time zone for me, you're going to be calling me outside of those hours. You can use the zip code. So the zip code often is really easy to help pinpoint what time zone a record is in. But again, there are some zip codes that do traverse multiple time zones. If you use the state, there are actually certain states that traverse multiple time zones. So you have to be cognizant of, if you're going to use that to calculate the time zone, that you only have that state eligible to be called at the later time for that particular state. I personally like a layered approach. So if you don't have the time zone already, like you're not capturing it on your form directly from the consumer, I recommend, and this is my recommendation, not legal advice, first do the zip code. Then if you don't have the zip code, do the state. Then if you don't have the state, do the phone number. If you don't have any of those three fields available to you, your fallback should be the one that is the latest date. So as an example, if I'm doing business on the East Coast and I am buying leads from California, if I do not have a way to calculate the time zone, I would recommend that you default to Pacific time zone for it. Okay. There's obviously some nuances to it, some things you want to think about with that component, but that's important to understand. Some other things that you need to think about, and Aaron, I'd like to get a little bit of your opinion on this as well, is that some of these states with their, either their mini TCPAs or consumer privacy laws have different requirements when it comes to call recordings. And, if you are actually telling the consumer or not that you are recording calls. So what are your thoughts on that?
Sure. That you've identified, Michael, a very important issue. And this is what people call the one-party consent versus two-party consent. Yep. So in a nutshell, the way phone recording rules work is you can have what is called a one-party consent or a two-party consent. One-party consent means that one of the people on the line can consent to the call being recorded.
Yep.
And that could be the outbound caller or the inbound caller, right? So you don't have to, if you're in a pure one-party consent state, you don't actually have to tell anybody. Tell the person you're calling.
Mm-hmm.
New York is an example of a one-party consent state. On the other hand, there are states where I am, like Florida, that are two-party consent states. And in a two-party consent state, you are required to get consent, notification, and at least, non-objection of the person who you're speaking with. So, and it has to be given very early on in the conversation. And sometimes it can be a little awkward, particularly for inbound calls is the one that I always get pushback from clients on. Outbound calls are easy enough. This is John calling on a recorded line.
That's right.
But inbound calls sometimes, if you don't have an IVR picking up, could be IVR, the automated voice picking up. But you have to be mindful of those. And the tricky part about one-party versus two-party consent is it could go by where the calls are originating from. So where, you, the outbound caller, are your call center is, but it could also potentially be governed by where the person is located. So unless you're very confident that you're in a one-party consent state and you're only calling into at least area codes that are also one-party consent, it's tough not to implement a consent to record disclosure.
That's right. And Aaron, I think you brought up a good point too with inbound calls. I actually just recommend through the IVR that you just play a recording to the customer that says, hey, this call may be recorded for, training purposes, compliance, et cetera. But for outbound calls, you need to be training your reps to say, hey, this call is recorded. I recommend if you're using like a contact center software or something, have a script. Have it displayed to the reps so they know exactly what to say to that customer and they're compliant, and then have certain practices in place where you are regularly auditing phone calls to ensure that they are properly disclosing that you are recording those phone calls.
Absolutely. And let me give you, Michael, I'm sorry.
No, that was good. Yeah, that was it.
Excellent. So let me give you the place where I have found, my hidden red flag. So my hidden red flag on the other one I mentioned, but on call recording, it's transfers. So, I've had people say, we solved inbound calls, we've solved outbound calls. And I say, okay, but what about the transfers? And what I mean by that is sometimes I've seen inbound calls which are not being recorded, but then go to in one department, but wind up being transferred to a different department. And that department, that second department, default is they record everything. And if the person calls that line originally, they would hit the IVR right away, as Michael said, that let's say you're calling, the customer service department. Mm-hmm. This is my example. if you're transferred, let's say from customer service to collections, let's say customer service doesn't have recording, but collections does.
Yep.
But if the rep at customer service, in my example, transfers you to collections who automatically records everything, that's where I've seen people get hit, that they don't realize that it's a transfer, but it really has to be treated as a new inbound call if your default is to record. I probably confused everybody with that example, but I've seen people get burned by that.
Yeah, and I've also seen some things where, some customers, they're like, well, I just, I don't record all the calls, or I record every call, but they don't have all their systems, their ducks in a row to make sure that you are properly disclosing that to customers. And then for the storage of the recordings, there are certain state regulations that say you have to, if you're recording calls, how long you have to store them, et cetera. You want to make sure that you have those records available to you. The next topic I'd like to talk about, Aaron, with this, and I'd like to get your opinion, is, we've seen in both the FCC regulations as well as the upcoming FTC TSR changes that there is certain storage of, call data that needs to be retained, as well as storage of the consent. So what are your thoughts on that?
Sure. I mean, you're exactly right, Michael. The paradigm is changing, right? So both with what Michael's referring to, of course, is the FCC amendments, which are presently scheduled to go, would become effective January 27th of 2025. There are some legal challenges to those, but the telemarketing sales rule recently had amendments that became effective, I guess I could still say last month for a little bit, that, have more storage requirements. And what the difference here is, now the storage requirements for the consent are now going to affirmatively be on the caller. So the paradigm before was you would have somebody challenge you, either a demand letter, and say, hey, you called me without consent, let's say at the demand letter stage, and you would then, work with your vendor and say, let me find the consent. What the new rule is going to be is that you have, as the outbound caller, have to have already store that. Now, it's tricky to me on how that's going to work in operation. How is it going to be enforced? What are you guys, Michael, from your perspective, how are you working with your clients to solve that issue?
Yeah, absolutely. So Active Prospect, we have a product called Trusted Form. And so what it is that as the consumer is going through, they're filling out the landing page, providing their consent with the disclosures, they submit it. We are recording that entire session, gathering all the information and a playback for the consent. And we actually offer another product called Verify, where you can actually look at the disclosures that are available on that page and do regular reviews and audits of those disclosures. So if a customer goes through that landing page, fills out the form, then it's submitted. Let's say you bought that lead from a lead provider. That lead provider can provide you with that certificate, and then on your side, you would claim it and store it within your CRM or your contact center software. So that way you have record of that consent, as well as the originator who originated that lead has that consent available to them. One of the things that we recently released with that Verify product is that if you've gone through, you've reviewed your disclosures. So, obviously, Aaron, you're very familiar with this. The TCPA, there's many different components of it, but like one of the more important components is just what's displaying on those disclosures, right? You can have somebody fill in a form, but if the disclosure is only 2 sentences and it doesn't mention certain things that you're going to do around like automated dialing, consent to text message, providing the express written consent, you're basically SOL in certain circumstances. So you need to be regularly auditing those disclosures. We have the ability to, as the customer fills out that form and submits it, we have the ability for you to confirm if that disclosure is on your approved list, and you can reject those records if need be.
Yeah, and I'll also mention we do have integrations with also for social lead ads for some platforms out there. So if their inlet process is collecting this information in social leads, we can help document that process as well. But yeah, auditing is crucial. Yeah. And making all our clients make sure you build a process Don't just because you have the trusted form that's capturing the consent transaction, you still need to have a process for occasional checking those things in automated fashion, but then also just going in and looking at the language occasionally, making sure that the language is appropriate.
Right. And that's the importance of, when you're going through the different products that you're using through your vendors, and you guys at Active Prospect, to me are the industry leader in capturing and verifying and documenting consent. But that's why now there's this, I wouldn't necessarily call it an additional product. It's just, to me, that's part of the solution that you need now, to have the live storage from the caller of the consent, because that's what the federal regulators at FTC and FCC are now saying you need to have to do.
Yeah, absolutely. And some things that we do have customers do as well is they actually, after the form is submitted and we've captured that consent, they use a tool called Lead Conduit that we offer. So the record will go into Lead Conduit and they do additional scrubs. So they confirm that they do a fraud check to make sure that consumer is the right consumer's identity. They confirm that the phone number is accurate. They've confirmed that the email is accurate. But one of the things that is important as well is we offer a known litigator scrub. So for those of you in the audience, I believe most of you are aware, but there are people that are out there that just go online. They fill out forms all the time, and then they try to seek class action lawsuits against certain organizations, and they sue you for millions of dollars. So we do have a way for you to help scrub against those known litigators before it actually hits your CRM system. So that way you don't call or text somebody on accident that may cause a class action lawsuit.
Yeah. And this is something, this is something that really happens. And it's not just the class actions. What you often will have is you will have your pro se people. So they don't even go out and get lawyers. And they'll sign up. Basically, they'll spend all day signing up on different web forms and just let the calls come in. And the calls will come in. They'll fire off their demand letters. And they're very systematic about it. They'll demand letters. And if you don't respond to them, all they have to do is pay $400 and they file a federal lawsuit. And if, often what will happen is if you call on that lead, 20 times, now all of a sudden you've got a pretty big individual problem, and you're going to have to, pay one of these pro se people to make this problem stop.
That's right. And something that I think is important, we actually had this question on the last webinar, but some companies believe that because they only have a certain number of employees or they're a certain size that, there's a very low likelihood that they could be hit with a class action lawsuit of some sort. And the situation is really, that's just not true, right? You can be sued regardless of the size of your organization.
Absolutely. Yeah. And I've seen, what did I say? The first, I've been doing this for 15 years. The first TCPA lawsuit that I ever had and how I got involved with it, it was a mom and pop scuba diving company. Really, literally, it was a mom and pop 2-person operation in South Florida. And there, at the time, there were several hundreds of people who were targeted for those. Some of it, sometimes there's insurance involved. So you could be a tiny company, but maybe you have a big insurance policy. Mm-hmm. So don't think just because you're a very, very small company, you're not going to be a live target.
Yeah. And I think it's also important. One of the takeaways here that I have for this from a systems perspective as well is that just because a certain system offers a product that they say, hey, this is compliant to state and federal regulations. First of all, ask them how and why. So like say, hey, provide me the details. Here's what I need you to do. And tell me how your system actually accomplishes each one of these tasks. And then you should also be doing regular audits of that system. So as an example, I have actually heard of situations where the programming of especially around text messaging tools, where the consumer will reply with stop, but the system doesn't read it. So, the system's looking for just stop, but not stop and period or stop in some sort of other component to it. And because it doesn't read it, then right then and there, you may end up texting them 2-3 days down the road, trigger a TCPA violation, and you end up with lawsuits.
Yeah, and just a very specific compliance sort of tip on that one, Michael, is if your system on your text says text stop to not want to receive text messages anymore, I can sort of offer what the courts have said is you can't restrict the manner in which you could withdraw consent so narrowly. And by the way, the rules that the FCC just came out with that became effective last month triple clarified that. So you really need to program your functionality that it's picking up any permutation of stop, any even typos that are close to it. And the point is, other people have thought about this. So there's solutions that have the 1,000 most likely things or whatever it is that people will text to mean stop, and that's really what you need to put in.
Yep.
Yeah, and from those vendor consideration, it brings to mind to me the old saying of trust but verify. Like you want to validate and explain it to me how that it works so that I can feel good and trust and have confidence in that. And that is a worthwhile discussion instead of just trusting that it might
that's exactly right.
have been demonstrated.
Yeah.
We have some good questions, but before we hop into the questions section, Aaron, I know we've been following along the developments with the FCC's declaratory ruling about implications of artificial intelligence, voice applying generative human voice. Is there anything in the states that is developing around this space, or the states staying out of this or trying to lean in, just sort of looking for a crystal ball? What are the things that we're seeing the states doing?
So nothing specific. I think there's one or two states that actually have put, kind of a more AI definition in their, robocall requirements.
Uh-huh.
I mean, within the next year, you're going to see a lot of state regulation around AI in general.
Yeah.
And I would watch the space to see if that extends to, to outbound or inbound calling. The interesting thing, TCPA is kind of, not that interesting of a story to me for AI because the statute already says artificial voice. I'm not sure there's a huge thing to be said for that. Although when the FCC came out with its AI guidance, there were probably 100 articles, and I said this is a snooze fest. They actually tackled that 33 years ago. But, watch the space. And if one of the states gets very specific on it, we'll have to come back and maybe have another session like this.
Okay. Yeah, that makes sense. It's a buzzy topic. So we certainly wanted to see if there was some developments in the states around this. So perhaps before we miss the questions, some key takeaways. Michael, I know you've been thinking about some of these items specifically for the audience here.
Yeah. So one thing that you really have to think about, and Aaron, you did a really, really good job of outlining this in the beginning, is that you really can't assume that the state-specific TCPA laws match exactly with the federal TCPA laws. There are things that are very similar in nature, but there are these things we talk about, like permissible calling times, disclosures of call recordings, et cetera, certain days that you can or cannot call, or certain holidays. So you want to make sure that you are cognizant of those and do your proper research with it. The second takeaway I had here was use technology to help you stay compliant wherever possible, right? You don't want to be doing a manual process with this. It's a complete nightmare. You want to use automated solutions with these third-party providers. And the third one is really, if you do not know where to find information about like these state-specific TCPA laws, you should seek counsel for this, right? There are certain firms that are out there that deal with specific regulations. You may go to your own internal legal team to talk about it, but also they may seek third-party counsel to provide it. Aaron, I did have one question for you. This one was actually from the crowd. What is a good resource to find information about a state-specific TCPA laws, or just some advice that you could provide for customers who want to know.
What's a good resource?
Yeah.
Google.
Okay, great.
I don't want to be flippant about it, but yeah, there's a lot of information that is readily available online. So I think what I would say is I like to think of this as the old 1980s NBC. The more you know. So the more you know message today to me is when I talk to people about state quote unquote TCPA is just be mindful that there's things that there are different state requirements.
That's right.
And, there's a wealth of resources that are available, and some of them are very good that lay out. There's charts, there's guidances. That's sure. Right. We've widely written on our firm website about this topic. So there's a lot of information out there.
Yeah, that's great. And we'll share that right now as well. Link to your bio and link to a number of the articles that you've written over the recent months, developing all those areas and things to watch out for. So we'll make sure to distribute that in the chat session here. That the next question, trying to grab one. Do the time of day rules only apply to cold calls? I thought that consent makes you exempt. Well, a cold call wouldn't have consent, so I'm trying to translate that one.
That one, let me see. So does the time to apply only to cold calls? I thought consent makes you exempt. So if I'm reading this correctly, is you're basically saying, hey, I have this customer's consent to call them. So they've gone online. They may have filled out a form. It goes into your CRM or contact center. Can I call them outside of the applicable hours for the TCPA? In most cases, that answer is probably no.
Right.
Yeah. There is a little bit of a gray area if the customer specifically tells you on the phone, hey, call me back at 9:30. I get off of work at that time. But if you're going through, you've got the consent for this customer, they've gone and filled out a form, you need to be cognizant of these hours as well as the days and the holidays.
Right. Yeah. Right. And I think exactly what I would say to that, Michael, is I don't think anybody is that specific. I mean, I guess theoretically you could be in your consent form that says, I give you consent to call me, at 11 p.m. Yeah. So if somebody put that in their consent form, you could have an interesting argument about whether you could have a direct consent that could override a state regulation. That's kind of a complicated argument about what you have to do to waive away statutory rights. But in general, outside of the example that Michael, you just gave, I would be very wary about making either debt collection or marketing calls outside of the time of day restrictions.
Yeah. There was another question from the crowd. How do the states handle customers who live in a state but have a mobile phone area code from another state? Do you have to key off the customer's residential address? So if I'm reading this correctly, what you're saying is that, and we talked a little bit about this earlier in the call. If I have a customer's information, right, it includes their phone number and their residential address. If their phone number is from an area code from another state, you really shouldn't be calculating the time zone based off of the area code as much as humanly possible. Now, I know there are circumstances that you do that. I personally would say you would go off of the residential address to calculate that time zone with the zip code.
Yeah, and it's you identified in this question identifies, and I know, Michael, you talked about this before. This is probably the hardest thing,
right,
in trying to figure out time of day. So Florida, for instance, has the rebuttable presumption about the area code, but now all of a sudden, as you said, everybody from New York and New Jersey and the Midwest who moved down to Florida but didn't change their telephone, now all of a sudden you have a problem. What I tell people is think of both, right? So if you could program your system to both account for the zip code and the area code, and it may narrow the time of day you have. You have a Florida area code and a California or even Hawaii zip code, but that's if you can put that double coding in place, that's probably to me, that's something to really think about.
So there was another question on here. If someone texts stop to texting, does that mean that you can't call anymore as well? You want to go ahead and take that one, Aaron?
Yeah. So let me I'm going to start with this question from a federal TCPA perspective. So from federal TCPA, there's not a separate restriction on text messaging. Text messaging under federal TCPA is just a type of call. So the answer is any withdrawal from any channel. If somebody says stop, you have to stop texting them, stop calling them, and stop faxing them. And I would say the same should apply for any regulation or any separate database you're maintaining for state permissions.
Yeah. And something to be kind of cognizant of this here, there are certain members in our crowd that they have like a corporate office, and the corporate office may have certain branches. And some instances I've seen branches that have different CRM systems that don't talk to each other. You need to understand that if a customer goes to one of these branches or replies to a text message from one of these branches and says stop, the rest of those systems need to be aware of that. Otherwise, they could end up contacting that customer and triggering a TCPA violation through that process.
Yeah, that's the big, to me, that's been a big thing in the last couple of years. When it's sort of the way I look at it is if you are marketing under so-and-so name or collecting debts under so-and-so name.
Yeah.
And somebody says, stop calling, stop texting, anybody else who's making outbound calls or text under that name, that needs to be in quote unquote to the system. And now the new federal presumption is that has to be acted on within 10 days. I say presumption, the federal rule is that has to be acted on within 10 days.
Yeah. And Aaron, I think you bring up a good point there because, there are certain members in our audience who we have some that have internal systems or auto dialers that they use and auto texting tools that they use, but we also have some that use third-party vendors to do calling on behalf or do texting on their behalf, et cetera. So they need to make sure that all of those systems are recognizing that opt-out. So you don't have a situation where your system, your internal system registered an opt-out, but then that third party that you've contracted with doesn't continue to send calls and text messages on your behalf.
Yeah. And there's one little, again, I've named my red flags in a couple different areas. One red flag that I'll put on this one. I submitted a comment on the rulemaking on this. The FCC I said it shouldn't be, they wanted to do 1 day. I said, at minimum, it should be 7 days, and they put 10 days. So I was happy that.
Yeah.
However, one of the other things I think my comment said was you shouldn't have what I'll call the service messages. If you're opting out on a service message, that shouldn't extend to a marketing message. So that also, particularly with debt collection calls, the FCC did not accept that. So the rule that people have to be mindful is if you are maintaining different databases for people who are receiving service messages versus marketing messages, now the opt-out has to be merged. So I've had a lot of larger organization clients that, the side of the house that deals with the service messages is completely different, has a completely different vendor, maybe in a different city than the side of the house that has the marketing messages. They now have to sync up in terms of documenting and ingesting and stop the stops.
Okay, I think we can fit one more question from our Q&A section. Did you see any good ones we want to grab there?
So, Aaron, I think this is a good one for you. We have a question in the audience. Does federal DNC apply to calls to business cells or landlines?
Sure. This is my favorite topic of like the last year.
Yeah.
So, this is such an exciting topic, not say exciting, interesting topic. To get back to it, in the statute itself in 1991 says what it applies to is residential calls. In 2003, the FCC said that the statute essentially presumptively applies if you put your number on the do not call list. However, if you have a line that you are primarily using for business, there is, the defendant, if they're sued in one of these, could make an argument that they should not be liable. So far at the courts, at the appellate court level, hasn't gone up to the Supreme Court, but at the federal appellate level, the Ninth Circuit, which is the appeals court on the West Coast, it's the only court at the appellate level has looked at this, and they put forth like a 5-part test. And that some of the factors are: how do you register the number with the cell phone company? Who's paying the bill? Are you primarily using it for business calls or personal calls? So that's sort of a very individualized thing. But here's what I would say. That's a good test if you're in litigation. You don't want to get there. All these arguments that from my litigation side that I can make if I'm defending a case, these are all things that, you're stuck in litigation. You're paying, somebody like me or somebody else a lot, unfortunately. Don't get there. I much prefer when people hire me for compliance engagements, because I know that the amount of money they're going to spend on compliance is like 1/10 of one TCPA demand letter and lawsuit. So it's really the two things I would say. Pitch for people like me, the ounce of prevention is worth the pound of cure. And really the pitch for somebody like what you guys are doing, that's really the front line of defense, making sure you are working with the right vendors and
that's right.
Understanding there are people out there that have been thinking about these things for many, many, many years and have very cost-effective solutions.
Yeah. And Aaron, I think you brought up a really, really good point too with that, because if you get to a point that you are in litigation, that becomes already expensive. You've got to you're going through discovery. You've got internal teams that have to go and research things for these allegations against you. And that's already expensive before you even get to the court, and you've got damages that are awarded against you. It's just better to be compliant out of the gate versus trying to play this game of like, well, if I find these little loopholes, hopefully I'm not going to get caught, or, hopefully it'll get dismissed in court. It's just too expensive of a game to play. I've seen companies bankrupted due to it.
Absolutely.
Yeah. Well, Aaron, thank you very much. It's a great reminder to everyone. Make sure you have good qualified legal advice and someone, a specialist who can navigate these, including the state-specific components as well. And I support those of, let's design some compliance strategies instead of trying to unpack the coming out of a litigation. It's well worth that investment, a solid investment in that. Last poll question we'll send out. Please check the poll questionnaire for that. Are you interested in learning more about Active Prospect Solutions? Let us know. You can respond right there. And also, we're going to have another series coming up. Episode 9 is on June 5th. That one is called Alignment, Auditing, and Adherence, the AAA Approach to TCPA Compliance. That's going to be featuring Peggy Daly from Charles River Associates, and also Benjamin Zitter, Chief Compliance Officer from What If Media Group. And we'll send out this recording session shortly tomorrow. And thank you, Aaron, for taking the time and educating us in all these areas. And Michael, thank you always for your knowledge in this space.
Thank you, guys. Thank you for having me. And I would sign up for the next one. Peggy is really one of my favorite people in this space.
Great. Thank you all.